Welcome back. Welcome back, everyone. Now we have, I would like to welcome Mr. Robert Bell. So, Rob, you're no stranger to the work of this committee. You have appeared before as a truck driver, but you're now in a new role. So I'll get you to inform the committee of who you are and what capacity you appear today before I give you the opportunity to go to the opening statement.
Okay, you can hear me okay?
Yes, perfect.
Okay, my name is Robert Bell and I'm a paralegal, or as they're known in New South Wales, a lay associate working under Adam Cockayne's supervision, a principal solicitor of Cockayne and Co-Solicitors, also operating under the name of Fine Defender.
Rob, I'm just going to stop you there. We've got some interference on the line. It's bubbly. Are you on a loudspeaker?
Hang on a minute, let me just... Is that better now?
Oh, that's perfect. Okay. Sorry, just start again, mate. I missed most of your opening statement. Start again, please, mate.
Okay. So, as I said, my name is Robert Bell, and I'm a paralegal lay associate working under Adam Cockayne, the principal solicitor, supervision of Cockayne and Co-Solicitors, also operating under the name of Fine Defender.
Okay, so thank you for that, Robert. Now, would you please go straight to the crux of your evidence, and we'll take it all in. Unfortunately, time is very limited, but please, I welcome every minute we have.
Okay. So last time I appeared, I spoke about wage theft, safe rates or lack thereof, and of the Australian transport industry in general terms. Nothing has changed in that regard. Today I wish to speak about heavy vehicle enforcement in New South Wales and the misery and hardship it imposes upon hard-working truck drivers, both in and out of New South Wales. The New South Wales government's enforcement regime in the heavy vehicle area is a disgrace. It is unlawful, unfair, and imposes unnecessary misery and hardship on drivers and operators. It is destroying livelihoods and families. It has nothing to do with safety. I'll qualify that though. If that was the objective, let's just pause with this thought for a minute. We know absolutely that safe rates and wage theft are a systemic problem in this industry. We also know that the cost of living places increasing pressure on household budgets to almost breaking point or beyond for many people these days. So the New South Wales government's response to that is to have an enforcement regime that seeks to punish drivers with manifestly excessive fines for the slightest error or technical error in their work diary, for instance, for getting to tick a box or putting down a parking bay out in the middle of nowhere instead of putting down GPS data, etc. And then if you end up in court with any of these, there'll be all sorts of victim impact levies and court levies applied as well. Then there's the cost. Enforcers a fine. If you can't pay, they will take away your licence, etc. All for what is often the most minor offence. Sometimes for an offence that they have simply made up. Now, with a great many of these offences having no utility with safety at all, and imposing a financial burden that for many is impossible to bear. I can say this with confidence because I've witnessed this during the 35 years or so I've been involved in the industry. Last year I said enough is enough, and for the past 7 months I've been employed as a paralegal in a legal practice, and we see this injustice every day, and we are now fighting back very hard on behalf of our clients to try and stop it. As I said, I work for Adam Cockayne, a solicitor who's been challenging the unlawful conduct of government agencies, local councils and police for years. His firm forced several councils in Victoria to refund over $25 million in illegal parking fines. And his complaints led to an ombudsman inquiry in Victoria that found the agencies had been acting contrary to law. We found that things aren't any different up here in New South Wales. We've identified many problems in the heavy vehicle enforcement regime, but it's probably best at this point to outline the many fingers in the pie in New South Wales. Under the road transport legislation, we have multiple agencies, or to use a buzzword, stakeholders, that had their fingers on our collective wallets and bank accounts. We have the NHVR, the sort of grand poobah that sits over the top and is responsible for the individual authorisation of some but not all of the enforcers. Let me just make one point here very clear, because it's often misunderstood. The heavy vehicle national law is not a Commonwealth law. It is not a federal law. The term national is a misnomer. It is failed legislation that has never achieved its stated purpose. For those that are interested to see that stated purpose, it's Section 3 of the Heavy Vehicle National Law. We have the New South Wales Police Force. Some say the best police force money can buy. Operating with almost zero accountability, they enforce the HVNL and other road transport legislation with almost military-style tactics. Operation this, operation that. And then we have the various divisions of transport for New South Wales, or whatever they're called this week. It is difficult to tell. There's still signs about New South Wales saying RTA. They have an enormous enforcement division with computers that spit out penalty notice like there is no tomorrow. There is a reason they changed their name from RMS, by the way, but we'll put that in submissions. And then we have local government having a crack at heavy vehicles as well at some places. Not to forget the mobile speed cameras run by private companies like Redflex, who now feel they have to operate covertly in the name of safety, of course. And then, of course, we have Revenue New South Wales, the debt collector. It is empowered under the Fines Act, New South Wales, to apply a new level of pain once the aforementioned are finished with you. Licence suspensions, siphoning of bank accounts, caveats on property, stopping you from registering your car or truck or renewing your licence. Things that only a court can do normally. All in partnership with Transport for New South Wales. All extrajudicial punishment. See Section 128 of the Fines Act for some guidance on that. So some of the issues we have identified with our clients include multiple offences or continuing offences. The machine that spews out these penalty notices has no off button, and we've experienced this through our clients just recently. So I probably won't have time to go through individual circumstances, but I'll make one point clear here now. Both the Heavy Vehicle National Law and the Road Transport New South Wales make it very clear that multiple offences are unlawful. Let me just let that sink in. If, for instance, if you're pulled up and they pick out 3 or 4 mistakes on one page of your logbook, they can only prosecute you for 1. That doesn't happen. We're always seeing stories of people, truck drivers charged with multiple offences. We have one client I'll just draw now that's got about $80-something thousand worth of fines of Revenue New South Wales, because every time he went under a certain camera and they couldn't recognise his number plate, he's issued a penalty notice for almost $1,500 in fraud and merit points, saying the vehicle is unregistered. That brings another offence that Transport for New South Wales are doing. If for some reason, as I said, they can't recognise a number plate, they say they deem the vehicle unregistered, even though the vehicle is registered. We've had charges withdrawn on that. It's an unlawful offence. It's absolute defence is available under the legislation. And it's just appalling that the Transport for New South Wales are making errors like this and continue to do so. No prosecutor should ever make a mistake of this magnitude. Remember, ignorance of the law is no excuse. We're also obtained through scrutinising the legislation that Transport for New South Wales are obtaining drivers' details unlawfully. They are not following the procedure. We believe this process invalidates the whole proceedings entirely. Transport for New South Wales are prosecuting some drivers illegally for offences when in fact it's the responsible owner or registered operator of the vehicle that is responsible. However, the low-hanging fruit is always the easier option. I know of one client who was charged with, he was not actually a truck driver, but used the truck for business, but he owns the business, it's his truck. A yellow sort of duplicate work diary page was stuck in his logbook. Went to Goulburn Court, Marool and Weybridge Court, hammered. Went to the District Court, appealed, got what they call a Section 10(1)A, which is a no conviction, etc., no fine. But the solicitor prosecuting for the RMS asked for $22,000 in costs.
Robert, I have to come in there. I just must come in there. I've asked, I know who you're talking about, Andrew. Andrew has provided me with a statement that I will read into Hansard. It'll probably take about 3 or 4 minutes.
All right.
I assume that's who you're talking about.
You're a mind reader there.
No, well, as soon as you said the yellow page. So, okay.
Yeah.
Sorry. So if you want to move on to some other stuff, Robert, and then I'll just have...
All right, sorry. Okay.
No, keep going because we are tight for time.
Okay, so that's why I'm sort of racing through it. The penalties imposed for a relatively minor breach are disproportionate to the level of offence. 20 penalty units for having a number plate slightly obscure, yet they can still read it. Huh? Now, we heard one of the other Senate witnesses talking yesterday about the fatigue clause at length and some of the unfairness attached to them. I'm not going to open that can of worms completely today, but I will bring up these salient points quickly. There are a number of fatigue management protocols in place under the HVNL. There's standard hours, 12 hours, relatively simple, just watch the overlap. There's BFM, 14 hours, but more rules and bigger penalties. But it allows drivers to be at work for 17 hours a day. Let that sink in, that's 17 hours a day. And there's AFM, where basically you make up your own rules. But then we have...
Fuel blockage. Got a gremlin in the line. While I'm waiting for Robert to come back on, I'll wait till he finishes. I'll give him a couple of minutes and I'll read this in Jerry. It won't take us long, mate. Okay. Are we still broadcasting? We're still on? No, keep going. I think if we've lost the witness, I'll read this statement into Hansard. Oh, look, let me do this while we're chasing up the witness we just lost. So, to those listening out there, I have had correspondence from Andrew Feller. I've spoken with Andrew on the phone over the weekend, and again, we've communicated this morning. And he sent me a message that I do wish to read in. And he said, Glenn, thanks for the chats recently. Here, as requested, is the short story version of my logbook fine adventure. It is some years ago, so from memory, I am an owner driver driving a 2007 R500 Scania, twin steer flat top rigid with super dog trailer, often loaded to 50-tonne GCM under permit, carting scrap metal from country New South Wales to Sydney. Marulan, HVIS and I are not friends because I am a scrappy. Presume because he carries scrap. I was given a ticket from Marulan HVIS after an inspector went through the pages of my logbook and spotted one yellow copy still in the book. The logbook has 100 triplicate pages and I had used 53 and so only one yellow out of the 53 entries remained. The book was several years old and it lives on the dash of the truck where it is often in the sun. I only cart my own scrap and was doing less trips those days, hence the book was old. I was charged with, and I quote, driver as record keeper, not keep record available. I defended the allegation in local court at Goulburn, self-representing and relying on a reasonable steps defence after I studied the transport legislation. I cross-examined the inspectors who ticketed me and they agreed the yellow and pink page edges were faded and could be mistaken for whites. I also tried to argue that the record was available. It was in the logbook. White is the original page, yellow is the employer copy and pink is the third copy, available to the RMS or the police or the National Heavy Vehicle Regulator to take on demand if they demand it. The yellow is supposed to be removed and stored at the nominated driver's base within 21 days. I also argued that it was far more appropriate for the RMS inspector to use his power of discretion to tell me about the yellow page, whereby I could remove it and store it at the driver base with all the other yellows rather than waste my time, court time and a costly and trivial prosecution. I was found guilty by the magistrate, my defence was ignored and I was convicted, fined, along with a cost award against me of $12,000. I appealed to the Goulburn District Court under Judge Frierson, again self-represented. The RMS was represented by private solicitors and this solicitor was Andrew Wozniak from Smythe Wozniak Lawyers. By this time I had realised I was slightly wrong with the reasonable steps defence and I was actually protected under the mistake in fact defence in the applicable road law. This defence is a common law defence and New South Wales is a common law jurisdiction. This defence provides that, in paraphrase, but for the knowledge of the fact the offence would not have occurred. This means that if I knew the yellow page was still in the book, I would most likely have removed it and therefore there was no offending or crime, that there was no means res or criminal action. The District Court spent the bulk of the day exploring my arguments. However, the DC judge ruled the charge was found proved, conviction confirmed, but the conviction was dismissed under section 10 in brackets 1 dot in brackets A dot of the Crime Sentencing Procedure Act of 1999. This means no fine, no conviction, matter dismissed. However, Wozniak asked for $22,000 in professional costs. However, the judge told Wozniak he had just dismissed the matter, so why should there be costs? And that the $22,000 was over the top. The judge then awarded $5,000 in professional costs against my further arguments. Revenue New South Wales then enforced this $5,000 professional cost as a fine and threatened to cancel my licence if I did not pay it. I had no choice but to pay the fine and it now exists on criminal record as a $5,000 fine, even though the charge was dismissed. This $5,000 was not money owing to the state of New South Wales. It was money owing to Wozniak. However, the state was used as a debt collector to get Wozniak his money. All this because I missed giving myself one single yellow page out of my logbook. Thanks, Glenn. And I unquote from Andrew Thaler. There you go, work that one out, guys. The truckies in the room are sort of stargazing. You're thinking, no, you couldn't make this crap up, but anyway, there you go. So, sorry, have we got... Robert, you're back online. I'm sorry I took your time because we lost you. So please carry on, mate.
That's okay. So I was up to, then we have 2 up, BFM 2 up. Probably the most dangerous of them all. So under BFM 2 up, under the fatigue laws, a 2 up driver can drive for 14 hours straight without having 1 minute's break, right? So there's no provisions in the BFM 2 up to have any breaks in a 14-hour period. As long as you have 10 hours off in a 24-hour period, you can drive for 14 hours straight. So most of that, well, a lot of that 2 up driving takes place in non-participating jurisdictions, so no cameras generally, and it's extremely dangerous. So the issue I talk about here goes to what they call parity and needs to be looked at. It's a ludicrous system with juxtaposed legislation and hopelessly complicated regulations. What is a critical offence in one instance is not an offence in another. So if the purpose of the law is to address fatigue, Why allow two-up drivers to drive 14 hours without arrest and then breach a driver on standard for starting work perhaps 15 minutes too early after having 8 or 9 hours sleep? It's ludicrous. It's probably best summed up in the words of former President of the New South Wales Supreme Court of Appeal, former High Court of Australia Justice His Honourable Michael Kirby, in the case named Able Proprietary Limited against the Attorney General of New South Wales, 1987, Volume 11, New South Wales Law Report, page 126 for those who are interested. When he was considering the provisions of the Gaming and Betting Act, but this particular quote is very relevant to what we're talking about today. The legislation relevant to the present appeal does nothing to add to the coherency of the body of the law. It is a jumble of ill-matched and poorly integrated enactments. If there is now to be found a common thread through it all, it would seem to be nothing more than revenue raising. I move now to accountability or lack thereof. As is commonplace in Australia, there's a distinct lack of accountability in most areas. In the area of enforcement in New South Wales specifically, it's blindingly obvious. Transport for New South Wales issue with a Canberra type offence, of which there are many. You seek your lawful right of review. Who reviews it? The debt collector, Revenue New South Wales. Absolute skin in the game. Same with police investigating police. We've done a lot of work in Victoria on this and now turning our attention to New South Wales, and we're quite disturbed what we've uncovered so far. Now, I want to tell you a story. This is an important story that really encapsulates the whole issue in New South Wales. I know a man called Wayne Suter from Victoria. Wayne owns a company doing horizontal boring. Wayne has an employee called Kevin Douglas Jesse, who drives a truck for him. I can say his name in public because Kevin Douglas Jesse has entered into the common law in New South Wales. It's on the public record. Kevin was driving Wayne's truck one day near Coolac when he was pulled into the weigh station in August 2017. Long story short, they issued a substantial load restraint breach to Kevin, despite nothing falling off his truck or remotely looking like it would or could. It was a steel-sided tipper with a small excavator strapped in, etc. He was made to unload the whole load, drive back to Wagga to purchase chains to come and then replace the more heavier rated straps he already had on the load and strain it all up and then put it all but load it back up together, complete with a penalty notice for $540 for a substantial load restraint breach. So he elected to go to court, at Gundagai Court, before Magistrate Beattie, and that court, he was found guilty and the fine went up from $540 to $2,500, including professional costs of $1,000 to a solicitor who has probably never read the load restraint guide in his life, much less understand it. So that went on appeal to the Wagga District Court in June 2018. By this time, Jesse and Mr. Suter were legally represented. So they went to all grounds appeal at Wagga District Court before District Court Judge Lur. This time, the District Court Judge dismissed the conviction appeal but upheld the severity appeal and reduced the fine to $1,000, saying it wasn't a substantial breach. So let's just see how you're going at court going so far. So at the request of the appellant, the District Court Judge stated the case to the Criminal Court of Appeal in New South Wales, where it was heard in July 2009 and a judgment was delivered in August 2019. The Court of Criminal Appeal ruled that the District Court Judge had misdirected himself in law as to the proper meaning of a contained load. In fact, he had ascribed the meaning himself. The Court of Criminal Appeal also held that at no stage prior did the prosecution bring it to the court's attention. The Court of Criminal Appeal then directed it to be sent back to the District Court at Albury this time to be heard at law. And that occurred in August. And this was in essence an appeal de novo, meaning it's a fresh appeal, appealing the original magistrate's ruling of the Gundagai magistrate, but with the Jiminy Cricket of the criminal court, the Court of Criminal Appeal looking over your shoulder. So District Court Judge Grant outlined a litany of errors, or worse, during his judgment. He describes it as reminiscent of the Charles Dickens fictional court case of Jarndyce against Jarndyce in the novel Bleak House. The prosecution admitted during this matter that the magistrate fell into error in a number of areas. District Court Judge Grant was extremely critical of the RMS officers at the initial intercept, stating that their opinion was plainly wrong. District Court Judge Grant was very critical of the prosecutor in the local court hearing, who brought up matters not particularised in the brief of evidence. So District Court Judge Grant allowed the appeal and dismissed the charge. So a great result in the end, and an enormous problem for past and future load restraint breaches, which are largely opinion-based in the first place. However, after the result, the appellant, Mr. Suter, in his legal representation, submitted a cost application for approximately $100,000. That is how much Mr. Suter had outlaid to solicitors to fight this case for his driver. And that was rejected by the district court judge, and a small concession of $1,000 of the original cost order was quashed. So despite laying out all the procedural unfairness, the prosecutor not disclosing information to the court, leading into an appellable error, we had a person that went all the way to the Court of Appeal and back, was proven to be correct, is now still $100,000 out of pocket. So this particular case, Senator, just outlines what hope have we got against this system when you're proven to be the correct and it still costs you $100,000.
Now, Rob, thank you for that. No, and I mean, that's gobsmacking. But the reason why we're getting into this part of the inquiry is that I had invited, or the committee had invited Transport New South Wales, which now incorporates RMS, to appear before the committee, and they didn't want to appear, but they did say they're happy to answer all questions, which is code for put it all in writing, and if you don't come up with names, addresses, times and all that, then I could possibly, or the witnesses could possibly be making it up, I don't know, which did disappoint me a little bit, because I would always think to myself that if you are part of the transport industry and you are doing the right thing, come along and tell the committee, tell the world that everything's roses and why you're doing it, and if there are some shortfalls, how do we address them? So I do appreciate that information. So Rob, I'll leave you on this. I will be writing as chair of the committee to Transport New South Wales, but I would, if I have to have the names of the clients or defendants, what I can guarantee is I'll treat them with the way the government treats me. I will redact all their names, their registration numbers, the dates, and treat them as the same cabbage they try to treat me when I seek information, and I can guarantee that.
Can I just leave you with one point, Senator?
You can, Rob. Yep.
So basically, I just want to make this point. I understand we're running short of time.
Yep.
But it may seem here I'm being critical of the courts, right? What I'm saying is I believe the courts are being led into error. The prosecutors working for the transport authorities are not fulfilling their duties, right? It's win at all costs. And this is where the system falls down and truck drivers are paying the price. And I'll leave you in the words of a Justice Gordon, formerly of the High Court, in the 2000 case, where Justice Gordon said, those exercising executive and administrative powers are as much subject to the law as those who are or may be affected by the exercise of those powers. The rule of law requires no less. And we believe that the rule of law is not being applied in New South Wales.
All right. Well, Rob, thank you very much. And I look forward to Transport New South Wales' responses, should they be listening in. Thank you very much for that. Now, as part of the request I put out the other day was I hear challenges where there's been overzealous enforcement, but I also take on board, and I will say this after talking to a lot of truck drivers, some truck drivers say a lot's got to do with attitude and a lot's got to do with, you know, if you speak to people how you like to be spoken to, and that's the way I like to try and work. So on saying that, I've said to people, look, give me some examples of what's going on. Now, I will give RMS, Transport New South Wales, the opportunity to defend, which we always do. So now